Okay.
The Fifth Amendment applies to you because you're a defendant, or you're a target of an investigation. That's when it applies. It doesn't apply to your friend who is standing in for Ms. Valentine as a witness, okay? And that is because the Fifth Amendment is only about self-incrimination, okay?
Okay, wait. Let's say she did come forward, and this is trial date, and she's sitting there on the stand, and you ask her questions, the prosecution asks her questions, and she just sits there. Well, first she says, I plead the Fifth, and she just sits there, saying nothing.
Well, what will happen is the judge will instruct your friend that you have immunity from everything you say because you were provided with a state attorney subpoena for a trial. So not only aren't you legitimately claiming the Fifth, but through the subpoena provided, this is provided by statute, once you get a trial subpoena from the state attorney, everything you say on the stand you have immunity for, okay? So again, the Fifth Amendment doubly doesn't apply because one, you're not a target of an investigation, and two, you have immunity. So the judge will say, answer the state attorney's questions, otherwise you're going to serve 180 days in jail.
Immunity from what?
Immunity from anything you say.
Immunity from impeachment? Immunity from...
No, immunity for being prosecuted for something that you would say.
Okay, but if you lie on the
so
stand, what is that called?
If your friend takes a stand and says, when the state attorney says, you know, tell us about what happened on...
Immunity from perjury?
I'll answer that in 1 second. Tell us what happened on November 7th, 2011 regarding you and Ms. Mullins. And your answer is, well, I was involved in a situation with Ms. Mullins, but I also killed 7 people, and their bodies are, you know, hidden underneath a house. Okay? And so you can't be prosecuted or that admission can't be used in the prosecution for those 7 bodies. Okay? That's how strong that immunity is. Now, regarding perjury, that is something different, okay? You never have protection from perjury, okay? But in order to prove perjury, you had to make another statement under oath and being on the stand. And, you know, I don't know that she's
made 4 different statements under oath. You have not retrieved all 4 of those statements, and you refused to send out depositions so that you can cross-examine her, so that you can have your ammunition.
No, I don't want her to testify. That's why I don't want her to testify.
If she refuses to come in for depositions, you're telling me that she is breaking the law, that she does not have a right to not come forward. She called the police. She initiated all of this. Okay? You're telling me that she does not have the right to say, you know what? I'm not going to talk to you. I'm not going to tell you that I lied to you to begin with, but I'm not going to talk to you. I'm not coming forward to this woman's trial.
No.
Let her go.
No.
You're telling me she doesn't have the right to say or do that.
No.
Because I can't press charges on her. The state has violated my right to do that. I only have 4 years to press charges on her. So at this point, so that you can have more ammunition, I'm sure, you know, she might just come forward. But you refuse to just send out depositions. Right.
I don't want her to come forward.
And then Mr. Taylor, you said Mr. Taylor, he was there. He was there. Now, you said the state attorney contacted Mr. Taylor.
Right.
I asked you to contact Mr. Taylor.
I don't want
to be a witness in my defense. He's not going to be a witness in her defense. He told the state attorney that they should not be prosecuting me.
Well.
So why have you not at least sent out depositions for Mr. Taylor? So
similar reasons.
If she does come to trial, you have Mr. Taylor to come and take the stand.
Ma'am, I've already answered those questions. Okay, and this is part of the listening part. Did you listen to what I said about keeping options open and what my strategy is right now?
We talked about witnesses for the state. I'm asking you about witnesses for my defense.
Okay. Well, actually, I asked a question. So why don't you answer my question?
Okay. What is your question?
My question is, I explained my strategy to you. I explained the reasons I'm doing what I'm doing.
You never did explain your strategy to me, except for you're telling me that if she refuses to come in for deposition, that she will be arrested, and the judge will make her take the stand, or else she serves 180 days in jail.
That's if I do what you want me to do. Why am I doing what I'm doing?
No, you gave me the scenario if she came in. So what if she does come into trial and you have not had that liberty to do, you didn't give yourself that option for depositions. Then now this is the day of
you're
trial.
avoiding my question.
Right.
What is my strategy? I explained it to you.
Your strategy is for me to take a plea deal.
Ultimately, to get some options for you. Yes. And how do I achieve that?
How do I achieve?
No, how do I achieve that?
Accepting a plea. How do you achieve that?
Yes.
You work with the state to get the plea offer.
That's not what I said.
And then you bring the paperwork to me to sign, and I'm not signing it.
It can't even be inferred that that's what I said. What did I say?
I'm not signing any plea offer. That's not an option for me. That's an option for you.
That wasn't my question.
Listen, when I spent one night in jail, when I was initially arrested on November 7th, 2011, I informed Ms. Deborah Munchell then that I would not take an offer for time served, and I had only served that one night. Now, I was held illegally without a bond for 9 months, sent to a state hospital illegally for 2 of those months. And the thank God for Dr. Chiata. He actually wrote a thorough report. Thank God. Thank God for Dr. Cassidy. Thank God.
Are your parents coming?
Now, illegally, no bond. My bond was never revoked.
Have they contacted you back?
No. They'll call you back. You called them. And I'll show this videotape to them. So they'll know exactly what happened here. I'm an adult.
Let's talk about the plea offer, okay? The state attorney hasn't made a plea offer at this point in time. If you go to trial, and if Ms. Valentine shows up and the jury believes that she was hit by you, and they don't, I don't know that we have a self-defense argument. I haven't got to that point of our discussion yet. But let's say they believe the state has proven their case beyond to the exclusion of a reasonable doubt that she was hit with pipe on her head, and that constitutes aggravated battery. And you're convicted. You understand that you're facing 15 years Florida State Prison from Judge Yancey.
Listen.
Now, that's an important question. I do want an answer. I do want an answer to that question. Do you understand that Judge Yancey can sentence you up to 15 years?
Absolutely.
Okay.
That's the statute.
And do you also understand that there are Florida guidelines, and under those Florida guidelines, you score out to approximately 3 years.
Can we talk about the facts of this case? You're telling me something. This is the only thing you ever tell me when I come into your office to try and threaten me.
No. I don't believe that you understand.
You're not wanting to do your job.
I don't believe that.
What evidence have you collected?
I don't believe that you understand the ramifications that you have in front of you.
What evidence have you collected to support my defense?
Tell me what the Florida guidelines mean and what they would mean in your case if you're convicted.
That's what the psychologist asked me.
Yeah, well, I'm asking you.
And it's in this report.
Well, go ahead. Tell me, what do the guidelines...
This is the last report.
Tell me what the guidelines mean. Do you have a copy of it, by the way?
I do.
Okay. So,
So you understand that I know, that the psychologist knows, that the public record, the public knows, that I am competent to proceed to trial.
So you understand that 34.6 months is the lowest permissible range. Okay, that means that you'd have to serve 34 months in state prison.
Listen,
because the
I
judge
already did 9 months.
Because the judge couldn't.
And I'm not taking a plea offer. So why are you going over this again?
Because I'm going to do it every time we meet, and every time to make sure that you understand what's happening, okay? Because again, I don't believe that you understand the seriousness of this.
So you're telling me that you have no evidence to support my defense?
Well,
that you believe that I'm guilty. That's what you're saying?
I believe there's a strong likelihood that if you go to trial, you're going to be convicted.
Okay, so what evidence have you collected to prepare for our day at trial?
Well, you tell me, Do you feel like you were acting in self-defense?
No, I did not tell you that.
No, I'm asking now. Do you feel like you were acting in self-defense?
No, I was not acting in self-defense.
Tell me why you don't think you were acting in self-defense.
Because for one, I never intentionally hit her against her will. That's what I've been charged with.
Did you grab any of the weapons or instruments?
Listen, I've given you, and I've also written 6 pages to what happened that day. 6 pages. It's on public record, court record. Okay? So
No,
what happened?
my record's not public.
Valentine also wrote a
Ma'am,
page
without going back in
that
time,
day.
answer my question now.
No, I'm telling you that
So
I
we're on the
not
same
only
page
told
now.
you verbally, but it's in
This
black
doesn't have
and
to be
white.
argumentative, okay? I want to go through this step by step, okay? So tell me why you don't think that you're acting in self-defense.
Listen, we're not here to discuss that. We've already talked about that.
We actually are.
This is my 4th time at your office. Your 4th time.
I want this to be a
in
substantive
over a year. And you're telling me that I need to go over that again. That
Yeah,
you
it's important
have
because
taken notes and you need me to give you the same information. See, the truth doesn't change. Lies do. So if you were to go to the
tell me the truth again.
Let me finish. If you were to go to Bartow Courthouse, collect those 4 sworn statements that Valentine has given. One which is with the detective again, but the other 3 are from restraining order court. One is handwritten in black and white. The other 2 are tape recordings from restraining order court. The other fifth sworn statement she gave was that her uncle's child, Percy Wingo, her uncle, who broke into my home. They broke into my home not just once, but at least twice. She was brought in to be a witness. Why? Why was she not charged? This is the evidence you need to uncover. Plus, on this report, this is the report by Dr. Kremper. He noted here that on November 7th, 2011, the officer did not show up at 7:39 a.m. The officer did not show up at 7:50 a.m. The officer did not show up at 8:15 a.m. The officer showed up at 8:33 a.m. over an hour later with my